truly an honor and pleasure to be with you, and it's wonderful to be with Professor Reich. I've admired him for so long, but this is the first time we've had the pleasure of meeting. I thought what I might do that's very useful is to talk about what the Constitution says and doesn't say with regard to impeachment. After all, impeachment is something that's provided for by the Constitution, and the Constitution has to govern the procedures that are used. I thought I would focus on 4 questions. First, what are the mechanisms for removing or sanctioning a president of the United States? Obviously, a president could choose to resign. That's happened once in American history, Richard Nixon in August 1974. Also, there is the 25th Amendment to the Constitution. It provides a procedure where the vice president and the majority of the cabinet could vote that a president is incapable of discharging the duties of office. If the president disagrees, then it would take a 2/3 vote of both houses of Congress to remove that person from office. There's been discussion about the 25th Amendment over the last 3 years, but I don't think it's been really serious conversation. Also, there is the possibility of a censure of a president. Both houses of Congress, by a majority vote, could choose to censure the President of the United States. This has been done once in American history. It was done to Andrew Jackson in 1834 for keeping certain documents secret. 3 years later, the Congress rescinded the censure of Andrew Jackson. I would not be surprised if down the road there is much more talk about censure of Donald Trump, as it may be clear that there's not 2/3 vote in the Senate to remove him, but a desire, perhaps a majority in both houses, to do something. There are no legal consequences to a censure. It is simply an expression of displeasure with the president, and it's obviously stronger than just displeasure, but that mechanism is there. And then, of course, there's impeachment. And the Constitution provides that the president, the vice president, federal judges, all office in the United States can be impeached and removed from office for, quote, treason, bribery, or other high crimes in misdemeanors. Impeachment comes to the United States from English law. In fact, might even trace it back to earlier countries than that. And it's clear that what was planned here was modeled to some extent on what England had. In England, if both the House of Commons and House of Lords agreed, an office holder could be removed. Not that different from the procedure in the Constitution. Well, that then leads me to the second question I want to address. What are impeachable offenses? I gave you the language of the Constitution: treason, bribery, or other high crimes and misdemeanors. The Constitution defines what's necessary for treason, and it makes it very difficult to prove that somebody has given, quote, aid and comfort to the enemy. Bribery has been defined by federal statutes since 1790. The real focus with regard to the Trump impeachment is, what does it mean to say other high crimes and misdemeanors? Gerald Ford, when he was in the House of Representatives, said, high crimes and misdemeanors means whatever a majority of the House and 2/3 of the Senate say it means. And in one sense, that's true. The House, by majority vote, can impeach. The Senate, by 2/3 vote, can convict and remove the person from office. On the other hand, I think these words of the Constitution should be interpreted like all other words of the Constitution. There should be meaning given to them. I'd start with the word other. I think that other tells us it needs to be something that's as serious as treason or bribery. There's a good deal of discussion of what high crimes and misdemeanors means at the Constitutional Convention and the Federalist Papers. And I think it meant to mean a serious abuse of power. Those are almost exactly the words that Alexander Hamilton used in defining high crimes and misdemeanors. There's often talk about what's the relationship of this phrase, high crimes and misdemeanors, to the criminal law. And I would say a criminal violation is neither necessary nor sufficient for it to be a high crime and misdemeanor. What I mean by that is there could be impeachable offenses, even though it is not criminal conduct, if it is a serious abuse of power. And again, you can find statements from the framers. You can even go back to English law and find support for the idea that high crimes and misdemeanors doesn't need to be a criminal act. But at the same time, a criminal act isn't sufficient. if it's a violation of a relatively trivial law, that wouldn't rise to the level of other high crime or misdemeanor. We can learn something from history. 19 times in American history, the House of Representatives has impeached. 9 times the Senate has convicted. That doesn't necessarily mean that in all the others the Senate acquitted. In some of those instances, once impeached, the individual then resigned from office. Almost all of those impeachments have been with regard to federal judges. 2 presidents have been impeached. There have been serious impeachment investigations before now of a 3rd. The first to be impeached was Andrew Johnson. It has to be remembered that Andrew Johnson was a Southerner. He had been a senator from Tennessee who had been named to run as Lincoln's vice president in 1864 for a unity ticket. Johnson was singled out because he didn't favor the South seceding from the Union. But he was very much a Southerner in his beliefs and his sensibilities. He strongly opposed Reconstruction. He vetoed the Reconstruction Act. And it was clear that this Southerner presiding over Reconstruction was very much disfavored by Congress. They saw him as trying to undo who had won the Civil War. Congress passed a statute called the Tenure in Office Act that said that if President Johnson fired any members of the cabinet, and these were Lincoln's cabinet officials, that would be deemed a high misdemeanor. It's clear that when Congress passed the Tenure in Office Act, they were setting this up to be an impeachable offense. Well, the cabinet officials, knowing they couldn't be fired, took full advantage of that. The then Secretary of War, Edwin Stanton, openly disobeyed Andrew Johnson and mocked Andrew Johnson. Johnson finally had enough and fired Stanton. Within days, the House of Representatives voted articles of impeachment, almost all focusing on how Johnson had violated the Tenure in Office Act. It was 1 vote short of what was necessary to convict in the Senate. It takes a 2/3 vote there, and they didn't have it, so Johnson could finish the term of president. There is no doubt today that the Tenure in Office Act was unconstitutional. The Supreme Court has explicitly held that the President of the United States has the authority to fire cabinet officials. So Johnson was impeached for violating a statute that's clearly unconstitutional. Nonetheless, it was just 1 vote short of removal. The second serious effort at impeachment didn't lead to one because the president resigned. And that, of course, was with regard to Richard Nixon in 1974. Everyone's familiar with how there was a burglary at the Democratic National Headquarters in June of 1972. There was then uncovered that this was a cover-up that led all the way to the campaign to re-elect the president, and perhaps to the president as well. The Senate Select Committee on Watergate in the summer of 1973, chaired by Senator Sam Ervin, held hearings. As part of the hearings, they learned there was a voice-activated recording system in the Oval Office, and there then ensued a year of litigation over the tapes in that system made public. What's often forgotten today is that the House of Representatives, through its Judiciary Committee, held impeachment hearings in June and July of 1974, while access to the tapes was still being litigated. And the House voted 3 articles of impeachment against Richard Nixon. And it was only after that, the House Judiciary Committee voted those articles, that the Supreme Court in United States versus Nixon ordered that Nixon have to produce the tapes. Nixon then released the tapes. At least one of the tapes showed that he engaged in obstruction of justice, and he resigned from office. So the House Judiciary Committee voting articles of impeachment, but it never went to the House of Representatives. The final instance in which there was consideration of impeachment of a president was of Bill Clinton in 1998. Whitewater's special prosecutor, Kenneth Starr, had a deposition where President Clinton denied having sex with Monica Lewinsky. This was regarded as perjury. It led to articles of impeachment being voted by the House Judiciary Committee and the House of Representatives, and the Senate did not convict. In fact, there was not even a majority in the Senate to remove President Clinton from office. That's it. That's the history of efforts to impeach a president. How does what's going on now relate to the question of high crimes and misdemeanors? And how does it going now relate to these earlier efforts in impeachment? I think it's important to note that this is much more similar to the Johnson and the Clinton impeachment than to the Nixon impeachment in terms of the relevance of fact-finding. For the Johnson and the Clinton impeachment, there was no real need to do extensive fact-finding. There was no dispute that Andrew Johnson fired Edwin Stanton. There was no dispute that Bill Clinton lied about having sex with Monica Lewinsky. The only question was, should that amount to a high crime or misdemeanor? With regard to Nixon, it was different. With regard to Nixon, there was always the question, what did the president know and when did the president know it? And I don't think until we got the Watergate tapes in August 1974 was that question answered. I think with regard to President Trump's statements with President Zelensky from the Ukraine, there's not really a dispute over what was said. I mean, we all know that President Trump said, I need a favor, though, in the context of the United States was going to give this military aid to the Ukraine. In fact, none other than Mick Mulvaney, the President and Chief of Staff, said, it was a quid pro quo. Get over it. So though there have been the hearings and there's going to be further hearings with the House Judiciary Committee, I don't think that the fact-finding is going to be nearly as important here as it was with regard to Nixon. I think this is going to be a question of, is this another high crime or misdemeanor? And I think ultimately it's going to come down to, on the one hand, those who say, this is a serious abuse of power. It's the president using the authority of the Oval Office to try to pressure a foreign country to investigate a political rival. And I think his defenders are going to say, this is something presidents do. It doesn't rise to the level of high crime and misdemeanor. And that's what the choice is going to be. Now, there might be other articles of impeachment voted. There's certainly the question of the emoluments clauses, and the president has been violating those since the beginning of taking office. Probably until January 2017, most people thought emoluments were just a skin cream. But Article 1, Section 9 says that a person who holds a position of trust in the federal government can't receive any presents or emoluments from a foreign government, emoluments being benefits. Article 2, Section 1 says that the president cannot receive any emoluments for serving in office other than the salary that's paid for it. I think there's no doubt that the president has been violating these provisions since the day he took office. I'm one of many lawyers who's involved in one of those lawsuits against the president, but they're pending. I don't know that they'll be done by the time President Trump is finished in office, but Congress could decide that's an impeachable offense. There's also the question of whether Congress is going to focus on obstruction of justice with regard to the investigation of Russia's involvement in the 2016 election. Special Prosecutor Robert Mueller was very clear in saying that under Justice Department rules, he could not indict a sitting president. Therefore, he said he would not express an opinion on whether President Trump committed a criminal act. I personally don't think that therefore follows, but he said it's left to the impeachment process to decide if the president has violated a crime. Congress may decide to pursue that as well. My own sense, and this is from being talked to several representatives and their staff, is that there's real disagreement among members of the House at this stage about whether to focus just on the Ukraine or whether to look at other impeachable offenses as well. Third question I was going to address, what procedures must be followed with regard to impeachment? The Constitution says the House has the sole power to impeach, and it's by a majority vote. It says that if the House impeaches, there is then a Senate trial. The Senate trial would be presided over by the Chief Justice of the United States, and in order to remove a president, it takes a two-thirds vote of the Senate. I have now told you everything the Constitution says about the procedures with regard to impeachment. If anyone wants to argue that the Constitution requires other procedures, that's their interpretation, not anything in the Constitution, not anything that any court has ever said. So examples. President Trump and his White House counsel, Pat Cipollone, said that there has to be a resolution by the House authorizing an impeachment inquiry. There is nothing in the Constitution that says that. No court has ever said that. Sometimes there has been, sometimes there hasn't been. President Trump last Thursday tweeted that his due process rights were violated by the procedures that the House had created. I don't think due process applies here at all in a constitutional sense. Due process applies only if the government is depriving a person of life, liberty, or property. A House inquiry isn't depriving anybody of life, liberty, or property. In fact, the House is much like a grand jury. A grand jury indicts somebody, and then there's a trial. Grand jury proceedings are entirely in secret. Now, I think it's important, for many reasons, to have open hearings before the House Judiciary Committee. I think that they should be fairly constructed, where both sides get the opportunity to call and cross-examine witnesses. But I do not believe that due process applies. President Trump has suggested that he has a right to know who his accuser is, specifically the whistleblower. Nonsense. There is nothing in the Constitution that requires that. The Sixth Amendment says that a person who is facing criminal penalties has the right to confront his or her accuser, but President Trump doesn't face any criminal penalties with regard to the impeachment proceedings. The question is, did he commit a high crime and misdemeanor? So I think it is very important, as you hear the rhetoric, to know that the Constitution says very little about the procedures. Well, fourth and final question. What's the role of the courts in all of this? And this is something, too, that's received a lot of media attention. And the answer is the courts are likely to play no role whatsoever. And this goes to a Supreme Court decision from 1993, Nixon versus the United States. The Nixon in this case was Walter Nixon, a federal district court judge from Mississippi. I'm sure it reflects my age, but I find a delicious irony that the only Supreme Court case in history to ever deal with impeachment still had the title Nixon versus the United States. After Walter Nixon was impeached by the House, the matter went to the Senate for a trial. The Senate formed a committee to hear the evidence against Walter Nixon and then make recommendations to the whole body. Nixon objected. He said the whole Senate should have to sit and try him. He took the case and went all the way to the Supreme Court, and the Supreme Court unanimously ruled against Walter Nixon. The Supreme Court said the challenges to the impeachment and removal process are not matters that the federal courts can hear. The Supreme Court said since the impeachment and removal process is one of the few checks on federal judges with life tenure, the courts should stay out of it entirely. And it's really left to Congress. So, in terms of some of the things I've heard speculation about, what if the House votes articles of impeachment and Mitch McConnell and the Senate say, that's nice, we're not going to hold a trial? I think that's clearly unconstitutional, just the thing it was clearly unconstitutional for them not to hold hearings and a vote on the nomination of Chief Judge Merrick Garland. But unless the court abandons Nixon versus the United States, there's nothing that can happen. Or another thing that really bothered me in the Clinton impeachment proceedings, the Senate trial was done entirely in secret. It was done entirely behind closed doors. The idea that the Senate can deliberate on whether to remove the President of the United States in secret is, to me, very offensive. But any effort to open it up failed, in part because of tradition, in part because the courts aren't involved. Now, if the President is impeached by the House, the President can never be pardoned for the offenses that led to the impeachment. The President can issue a pardon for anyone accused or convicted of federal crime, but there's one exception in the Constitution. Once there's been an impeachment, there can never be a pardon for those offenses. So Bill Clinton can never be pardoned for the offenses for which he was impeached. Had the House Representatives as a whole voted articles of impeachment against Richard Nixon, Gerald Ford couldn't have pardoned him. And the Constitution also sets up two separate questions. Should the person be removed from office? And second, should the person be disqualified from holding future office? Those are not the same question. Through most of history, when a person has been removed, they've also been disqualified. But I could imagine, given the timing, the Senate could conceivably have to consider independently, should the president be removed? Should the Senate then also disqualify the president from being able to run again in 2020? So that's the quick summary of what the Constitution says about impeachment. And the bottom line is, it doesn't say very much.